Hello, I'm Bill Reid, and I'm the lawyer who provides the legal service to Georgia Brown College students through the Student Association. Today we're going to talk about family law. First we'll talk about marriage. Marriage is a legal status that can only be acquired through specific procedures established by a government authority, either in Canada or elsewhere. And the marriage that takes place in one jurisdiction is usually valid throughout the world. Common law, on the other hand, is a status that is not conferred by any one authority. Accordingly, different authorities establish different conditions that constitute common law for their purposes. So in Canada, for example, for immigration purposes, a couple is regarded as common law if they have lived together for at least 1 year. For family law purposes in Ontario, a couple has to have been together for at least 3 years or had a child together. So that's why I say that the status of common law is not conferred by any government authority, thereby applying to everyone else. It's just that certain government authorities in Canada will regard a couple as being common law after certain conditions are met for their purposes. A couple that is either married or common law may become separated just by establishing separate residences. However, just as marriage only exists if procedures established by a law have been followed, divorce can only be achieved by following certain procedures established by a particular jurisdiction. So again, a couple can become separated. They don't need anyone's approval, anyone's documentation, but to become divorced, yes, that does require application to a government authority and complying with that authority's regulations. Someone who has lived in Ontario for at least 1 year may apply for divorce if other required grounds exist, regardless of where they were married. So someone married someplace outside of Ontario may apply for and obtain a divorce in Ontario. And again, a Canadian divorce should be recognized anywhere in the world for legal purposes. A married couple that separates permanently will need to divide their assets and debts, and most of those will belong to both of them equally, regardless of which of them is the registered owner. They will also have to deal with the issue of spousal support, meaning whether one spouse pays the other ongoing financial support just to maintain a lifestyle that was similar to when they lived together as a married couple. They will need to deal with these issues whether or not they eventually divorce. Some couples separate, establish their separate financial situations, and never divorce. Others do proceed to divorce after required time periods are met. Now, common law partners who separate normally keep whatever is in their respective names and divide only whatever they own jointly. There may be circumstances in which one of the partners has a claim on something that is in the other one's name. For example, if a house is owned by one of them, but the spouse who isn't entitled to the house did a lot to help to repair, to clean, gardening, whether financial investment or other ways, they may be able to make at least a small claim against the title to that house that theoretically is owned entirely by the other partner. In any event, the issue of spousal support exists much the way it does in the case of a marriage. If a couple has been common law and they separate, and one is able to achieve a higher standard of living than the other, then the one with the higher standard of living may owe the other spousal support, even though they were not legally married, at least for a limited time. Now, if two parents of children live together, regardless of whether they are married or ever were married or were just common law, or even if they never lived together, they will need to deal with issues pertaining to the children, which include decision-making responsibility, which formerly was referred to as custody, but now in Ontario is decision-making responsibility. Also parenting time, which used to be called access, is now called parenting time, and also child support, which we still call child support. Now, the two parents may come to terms about these things by way of a private agreement, either oral or in writing, or if they're not able to agree, then either one may file a court application. A court application will result in a court order. And once a court application is filed, the couples may then find that they're able to agree and that the judge is therefore able to issue a consent court order, a court order that both parties agree to on consent. If the parties are still not able to achieve that kind of agreement, then eventually a judge will impose an order on both parents pertaining to those children. Now, I mentioned before about decision-making responsibility, and that we used to call it custody, and that pertains to who makes the important decisions in a child's life about things like health, education, extracurricular activities, and religion. It doesn't pertain to necessarily where the child lives. So decision-making responsibility may be sole, S-O-L-E, where one parent makes all the decisions. It may be joint, where the parents make them together, if they're able to do so. That's ideal. Or what is called shared decision-making, where each parent makes the important decisions when the child is with them. Again, these are things that the parents may be able to agree to. If they're not, a judge will make an order determining who has decision-making responsibility and whether it is sole, joint, or shared. As I said, it's not about where the child lives, it's about making the important decisions. So it's possible that one parent may have sole decision-making responsibility and be the child's primary residence, but it's also possible that the child's primary residence may be with one parent while the parents have joint decision-making responsibility. Or alternatively, that one parent has sole decision-making responsibility, but the child lives equal time with both parents. Those are all possibilities because they're separate concepts. A parent that a child does not live with may be granted parenting time and may have to pay child support in an amount set by the government. The government of Canada has child support tables, and they indicate the level of support that a parent must pay depending upon the province in which they live, their income level, and how many children there are. Parenting time may be on specific days and times, or it may be left to be agreed between the parties each time it takes place, what is sometimes referred to as just reasonable parenting time on reasonable notice. And the specific amount of child support, as I said, depends on also what percentage of a week the child lives with each parent, as well as the province, how many children, and the income levels of the parents. And that brings us to the end of this presentation, but I hope you found it informative, and I can be reached by email confidentially by individual students so we can discuss individual situations about family law or any other legal issue through the email address legal, L-E-G-A-L, at sagbc.ca for Student Association of George Brown College, legal at sagbc.ca.